Test 1, 2, 3, 4. Check 1, 2. Check, check 1, 2. How's that look? Either bring it downstairs or we put it in the closet or something and glossy air. Whatever you want to do. Yep. No, how come it's got that curve to it? Yeah.
I think this might be the camera.
No, it should be fine. Yeah, it should be fine. Get some air through here.
Okay. Okay.
Oh, that's perfect. Oh, wait, no.
I'm just saying, I don't know how that's all gonna work. I just found that out. Yes.
I thought they were eating here, Celine.
Maybe they could.
Yeah, that's what I understand. They're
No.
eating.
Not enough distance. She wants the distance.
Okay.
That's too close.
So one.
You're gonna have to move her over a little. Yeah, she wants the distance. So
Okay.
I'll let her.
Yeah.
I should have her come and take a look at this. You know what?
Well, when they come in, they'll be here.
Yes.
Facilities
When
will be
they
here, right?
conference after hearings, they're all gonna come down here. She'll make sure that they are distanced enough to sit between, to conference, and then they'll probably just stay right there and eat their lunch.
Awesome.
Okay, just for today. Okay, good luck.
I just read that. 20 minute delay.
October 6, 2020 at 9:30 a.m. State of Rhode Island versus Joseph Seagrain. Counsel, please identify yourselves.
It's Christopher Gontas on behalf of Joseph Seagrain, the appellant.
Owen Murphy for the state of Rhode Island.
We all set?
All set.
Thank you for joining us on this remote hearing. The rules are the same. Mr. Gontars, you'll have 10 minutes with a 2-minute rebuttal. You may proceed.
Thank you, Chief Justice Patel. May it please the court. The defendant appellant, waived an information on January 10th, 2012, in front of Judge Daniel Procaccini on a 2-count criminal complaint that charged him with count 1 was possession of marijuana with intent to deliver. He had 36.51 grams or 1.2 ounces. And count 2 was maintaining a narcotic nuisance. And as a result, he received the following sentence. He got 10 years with 1 to serve and 9 suspended.
So that tells us something, Mr. Gontas. It tells us if he waived indictment that he was being held as a violator. And he, rather than admit violation or be sentenced as a violator because of the parole eligibility considerations, he waived indictment, did he not?
I believe, yes, he waived that information.
What was the underlying charge for which he was being held as a violator? Do we know?
I believe it was a possession of a controlled substance charge.
Okay. So he's on his second drug charge.
That's correct, Your Honor.
Okay, and he gets 10 years.
On the outside and 1 year to serve.
Yeah, but he got a 10-year sentence, and it's at least his second drug charge. Is that right?
That is correct.
And then he's up on a gun charge.
Yes.
Okay.
The defendant, on January 12th, 2017.
Excuse me, Mr. Grantas, may I ask you, has the gun charge been resolved?
Oh, yes, it has been.
And how many was he found guilty?
Yes, he was.
And how many years did he get?
A lot. I believe there's mandatory consecutive sentences on the gun charge.
So what difference does any of this make?
Well, is it on appeal to us?
It's the gun charge. Yes, both cases were tried by Judy Kroll in the Superior Court, and Rick Corley was representing him on both these cases that were before the court. This court. I was appointed last fall to represent him on both appeals after he had a disciplinary complaint filed with Mr. Corley, and subsequently this particular 12A petition was pre-briefed with Justice Indelia, and now subsequently was put down for the show court hearing. The gun case, the underlying offense or the triggering offense, as this court refers to them, has yet to have a date for an assignment, even though both sides have briefed it.
An assignment in this court?
Yes.
Okay, so he was found guilty by a jury who did not plead?
That is correct.
All right, go ahead.
And he got 80 years, as I count it.
Yes, he got a substantial sentence, Your Honor.
And this emanated from the Superior Court, is that right? This whole
That is
thing
correct.
started in the Superior Court and wound up with a shooting right outside the courthouse, is that right?
That's what he was found guilty of, Your Honor.
Okay, thank you. Hey, welcome aboard, Mr. Murphy. Well.
Well, now we can't hear you.
I think he's
I can't
muted.
hear you.
Oh, there we go.
There we go.
Good to be seen and to see.
Well, we can only see half your face, so you need to adjust. There we go.
All right.
Okay.
We're gonna get there.
This is cutting into Mr. Gontarez's time.
We'll give you the extra time, Mr. Gontarez.
Thank you. I'm well aware of, the standard that this court utilizes in reviewing probation violations, which is an abuse of discretion only. And, that is, was it arbitrary or capricious that in finding the violation? And in fact, it was another Justice Vogel case, that one of the cases I cited was State versus Simpson. Again, that was the standard. And again, I'm well aware, and so is my client, and I saw Mr. Murphy's brief regarding, about what the focus should be on whether or not it should be the first offense or the second offense, or the underlying offense is taken into account. What I'd like to bring to the court's attention, and I think it's very informative, and I think Justice Goldberg's questions regarding the triggering offense about the shooting outside the courthouse, which was, in this case, the sentencing justice, kind of dismissively noted the imposition of the criminal sentence as a pretty generous one in light of, even though it was 10 years, it was 1 year to serve. And, she made that statement without any information before her other than...
Well, it is, Jim. It is. It's a waiver of information, so you don't go on a violation. You continued on the same, I'm sure, although I have not checked that record. Waiver of information, and you cut loose after a year. But you promised 10 years. So you go from a drug charge to a drug charge to a gun charge.
I agree on the litany of the charges, Your Honor. But the question becomes whether or not, the sentencing justice in this particular case had any facts other than the triggering offense.
She is not the sentencing justice.
On the violation.
The sentencing justice was Justice Procaccini.
No, but
She's just deciding how much of the suspension should be lifted.
I agree, but she's...
That's not imposing a sentence.
Mr. Lopez, excuse me for interrupting you, but that's, you don't seem to be contesting the merits of the violation so much as the sentence, right?
That's correct.
And are you saying that she doesn't have a right to look at the seriousness of the new charge when she takes that into consideration as an indication of his...
It should be one factor. It should be the controlling factor.
I'm sorry, you have to say that again.
Okay, I'm sorry. I spoke over you. I didn't mean to do that.
That's okay.
It should be a factor, but it shouldn't be the controlling factor. And in this particular case, she specifically said, I reviewed the criminal information, when I'm going to impose this sentence. There was no criminal information before her since there was a waiver. All there was a copy of the complaint. And she heard all of these facts regarding the underlying offense, and is solely based on that, she gave him the 9 years.
Well, she found that he was not a good candidate for rehabilitation. That's certainly a factor that she can consider.
I agree. But again, it's based upon her statement in the record. I reviewed the criminal information package. There was no criminal information package.
Well, there was on the violation, was there not?
No, on the violation, what my experience, Your Honor, the violation on the 32F that's presented would be the triggering offense of the gunshot.
We're getting some feedback somewhere. All right, go ahead.
You better repeat that last sentence. I got too much static.
I'm trying to my experience has been on 32Fs is that what's attached to the 32F is the underlying offense and the sentence that was imposed, but not the old case. What's attached is the triggering offense. So that, again, the facts were based strictly on the shooting and had nothing to do with the underlying offense. And the one final thing I'd like to bring to the court's attention is that in Mr. Murphy's 12A statement to the court, Mr. Coley he's rebutting something Mr. Coley brought to the court's attention, which was about the decriminalization of marijuana. And I'm not suggesting, and neither was Mr. Coley, that that possession with intent to deliver was decriminalized. But also they made decriminalization less than an ounce of marijuana. And I'm going to suggest to you that he pled in 2012 to 1.2 ounces of marijuana. So we're not talking a substantial, 50-pound deal here.
Well, then why was he sentenced to 10 years? He agreed to a sentence of 10 years, Mr. Gontas. You're basically asking Justice Vogel to look behind what Justice Procaccini did. And we can't do that. I mean, there were some judges around. Judge Israel, you went to him for a violation hearing. You got the whole boat. Whatever it was, that he found you to be a violator. Whatever the sentence was, is what he imposed.
There's still some of those around, Judge. I've run into them.
Yep.
Well, for the
Did he contest this violation, or did he admit the violation here?
On
this?
He contested it.
Contested this one, yes.
The
Okay.
hearing was lasted 5 days.
Yeah, that's right.
Right. For those reasons set forth in both Mr. Coley's brief and my own, as well as the oral argument, I respectfully request that the court remand this matter for a new violation hearing. Thank you.
Thank you very much. Mr. Murphy.
Let me apologize one more time for my technical difficulties this morning. I have a brand new computer that works wonderfully, and then as of an hour ago, it just inexplicably won't let me shut it down or restart it, and it's just kind of floating in limbo. And I'd like to apologize to the court for that.
We're all familiar with those problems.
Yes, hopefully we'll get this to be a smooth running engine soon, hopefully. As far as this case, Your Honors, it's the state's suggestion that while the trial justice certainly considered the conduct and the violating conduct, it was her right to do that, and she only did it within the guise of her conclusion that the defendant was unfit for rehabilitation, which certainly was a fair sentencing consideration that's permitted by this court's jurisprudence. And as far as, I just briefly like to address
And
that.
what facts did she conclude that?
I think expressly in her sentencing decision, she refers to the defendant's new violating conduct, that is gun cases, as a basis to say that clearly he wasn't fit for rehabilitation. I think it goes without saying that that's a prudent observation given the severity of that gun case. That was the shooting outside the court, and the events precipitating that shooting took place in the courtroom when the defendant was engaging rival gang members and so on and so forth. So
That was Puckett East and Puckett West, right?
That's correct. That's correct. And that the defendant appealed those charges too, but he withdrew that brief, and that case is now settled.
Which one?
He took a direct appeal from the shooting case.
And he got the one he received 80 years on.
That's correct.
Is that
Has that been
pending?
resolved?
He withdrew that appeal in,
Oh,
I want to say September. I looked at the docket the other day, and yeah, he did withdraw that claim. I'm not sure.
that's apparently news to Mr. Gontas.
Unless I misread the docket, but that's what it looks like to me.
You could be right. I'm sure some of our crackerjack law clerks that are working behind the scenes will let us know that pretty quickly. But you could be right. We had something on the calendar, the conference calendar.
Yeah, I think it was scheduled for oral argument and then taken off the calendar. I could be wrong about that, but at least as my reading is the docket as of yesterday, that case was taken off. And I think it's briefly worth noting, as far as State versus Fortes is considered, and I should have discussed this more fully in my brief, and I didn't, but the reasoning in that case was pulled back in by a number of subsequent decisions, including State versus Wisehart, which I had in my notes on my computer that doesn't work. But yeah, I actually have it here. The site to that is 569 A2D 5. The rule in Fortes only to first-time offenders on who
Yeah.
are on probation for.
The arrest on the case before us, for which he waived and received the 10 years, also indicated that and these counts were dismissed pursuant to Rule 48A, also indicated that he was distributing in a school zone, and that he had been convicted of a prior drug offense on May 3rd, 2006, which must have been the violation. I hope I'm not scaring you away here, Mr. Murphy, but you faded out again. There we go. I would suggest you check your bandwidth.
Yeah,
That's what happened to me last week.
Yeah, I'm using my phone as an internet connection for my iPad. I've really had to guinea rigs.
Are you in the office or at home? You're not in the office?
I am in the office.
Well, don't they have any little guys that can come in or gals that get this thing going for you?
Yeah, we're probably gonna have to do that for my next argument.
Thank you.
That would be helpful.
Okay. Yeah, I know. Again, I apologize. But to briefly conclude.
I'm not hearing.
No,
Yeah, you're muted, Mr. Murphy.
Sorry.
I think we've
Oh,
lost.
I'm not muted. I'm just,
It's called low bandwidth.
You're lost in cyber world.
yeah. I don't know if you guys can hear me, but the defendant had a number of convictions under his belt already.
Yeah.
Him.
We've lost your audio again, Mr. Murphy.
I'm gonna try and call in. All right, can you guys see me now?
Oh, we got you now. You're on.
All right, I just wanted to briefly say that the Fortes decision is not applicable to the defendant who, in my review of his record, has multiple assault cases and at least one prior drug conviction independent of that underlying offense that he violated his probation on. It was a cocaine distribution case. So all his reliance on that case really has no action as far as the violation that the justice found in this case. If there's no further questions, the state's satisfied to rest on its brief.
Thank you very much. Mr. Gontars, you may have 2 minutes.
Thank you, Chief Justice Patel. Just, I believe to clarify on the triggering offense, and I submitted when Chief Machakmo advised me that, a brief was due, and I submitted a motion to withdraw the motion to submit an additional brief and to rely on the brief and a reply brief to the state. But I believe that was not, it wasn't the intention to withdraw the appeal on the 80-year sentence at all.
I'm sure that can be corrected once we take a look at those records.
Yeah, and if there was it's my responsibility, it'd be my error if it was done, but it was not intended to withdraw that brief at all.
I'm sure it can be corrected. This is a whopper.
Yeah, you moved to,
That's putting it mildly, Judge.
you moved to withdraw your reply brief or are you going to substitute a brief for Mr. Corley's and then you withdrew that suggestion? So
That's
Mr.
correct. I read all 32 volumes of the transcript and realized that all I would be doing would be repeating what Mr. Corley said. So I wrote, I again, submitted a reply brief.
I think that's what was on the calendar.
That was,
You're
yeah.
right.
Calendar. I'm fairly certain that's what was on the conference calendar.
We'll
All right,
look
thank
into
you.
it.
That's why when Justice Flaherty said, I looked surprised, I almost fell off my seat, to be candid.
Well, we want to keep you in your seat.
Well, it's interesting talking to you all sitting down, and thank you for the consideration.
You're very welcome. Thank you both. And Mr. Murphy, we'll see you later, I gather. Hopefully we'll hear you too, because we can't hear you now.
Then too, because we can't hear you now.
That time I was muted. I was saying, yes, let's hope that I reappear.
Thank you
everyone.
very much.
Thank you.
Thank you.
Good morning.
Good morning. The Rhode Island Good morning. The Rhode Island Supreme Court show cause calendar for Tuesday, October 6, 2020 at 10 a.m. Michael Salvatore versus Thomas Palanggio. Counsel, please identify yourselves.
John D. Simone for Thomas Palanggio.
Good morning, Attorney Nicole Martucci for the appellee, Michael Salvatore.
Good morning to you both and welcome to the Rhode Island Supreme Court, the remote version of the Supreme Court at least. We've been conducting these hearings and they've been fairly successful. Mr. DeSimone, the rules are the same. You each have 10 minutes to argue. Mr. DeSimone, you'll have a 2-minute rebuttal period if you wish. You may proceed.
Thank you, Your Honor. Members of the court. This case involved a lengthy hearing with some preliminary motions, procedural motions that I think by the judge's rulings, they prejudiced my client in the sense that if you look at the complaint, there were allegations in the complaint that really had to do with his position as a state representative. And as you all know, sometimes that could be somewhat prejudicial, in this day and age. And specifically, one of the counts there was an allegation that he somehow abused his office, his ethical duty in his office. And we asked the judge to strike that count, but the judge refused to do so. So as a consequence, the jury heard throughout the entire trial that he was a state representative. There was cases, questions that pertain to whether or not he could take Mr. Salvatore off the toll list. So frankly, Your Honors, I felt as though I just had that feeling that my client really never got a fair shake because of the pretrial decisions of the judge. Not purposely, but the effect was that he was prejudiced right from the outset. And in one instance in voir dire, he even mentioned that I was a state representative. So, you know, I would submit to the court that that was an abuse of discretion. At the very least, Mr. Palanggio was entitled to a new trial. I mean, those facts and questions regarding, you know, that type of conduct by an elected official.
But wasn't some of the evidence, and I can appreciate your concerns, Mr. DeSimone, but wasn't some of the evidence that your client, at least the allegation was, your client threatened the defendant in this case?
Well, that's a good point, Judge. That was the count that I'm speaking of. I think it was count 6 or 7, where he alleged that, and he tried to testify to that.
Did you ask to sever that count?
I asked to sever that at the beginning because it was totally unfounded. It had nothing to do with the original case. The original case was...
And you filed a written motion to sever?
What I did, Judge, was I filed a motion in limine to strike the count because it had no bearing on the ultimate...
That's not a motion to sever.
Well, no, it wasn't a motion to sever. It was a motion in limine because it was obvious he made the allegation on the Ethics Commission. He said it was unethical. And the Ethics Commission has their own jurisdiction. At the end of the case, the judge dismissed it. The only counts that he left was the promissory estoppel and unjust enrichment counts. So my point was, I said to the judge, I said, Judge, there's nothing in this case regarding that.
Regarding what? Regarding what?
Regarding his trying to intimidate him on the toll list. My client...
That wasn't the case until the final 2 counts were the only ones left.
I can't hear you, Justice Robinson.
Those facts were in the case until only the final 2 counts remained.
Well, no. I alleged in the in limine motion that there were no facts to substantiate.
I understand that, but after that motion was denied, there was evidence or an attempt at evidence to substantiate those counts.
Well, they never put any evidence in to substantiate those counts, and that's why the judge struck it from the record. He eventually dismissed it. He agreed with me, but it was only the jury heard everything about it. He heard that he was a state representative. The whole purpose was I didn't want to cloud the issue of him being a state representative. And in my mind, those counts were only put in. It was an amended complaint. Those counts were only put in to prejudice Mr. Palanggio. I mean, there's no question about it. How could a state rep, and let's be mindful of the fact that the plaintiff here is a successful businessman. He testified he owned 15 to 17 properties. He was on numerous municipal toll lists. Anyone who knows anything about toll lists, some of you do.
We missed you.
No.
We missed your last sentence.
My point was, yes, my point was that as a state representative, Michael Salvatore knew very well Tom Palanggio had no power to take him off a state police toll list, or any toll list for that matter. It was purely made up so that he could smudge his reputation in front of the jury. And in my mind, I think it worked. I mean, I've been in the business of people for a long time, and I just got that gut feeling that Mr. Palanggio never had a fair trial here. But then getting to the, and I hope, you know, you would take that into consideration. But
Did you move to exclude that evidence during the trial?
Yes, Your Honor. I moved in limine.
All right.
I moved in limine, and I told Judge Stern I said, look, if they keep bringing up the fact he's a state representative, and this count, which we agreed with me later, was the jurisdiction of the Ethics Commission, he could have determined that right at the outset.
When you moved, I'm sorry to interrupt you, sir. When you moved in limine, did you object again when it came in?
I objected a million times, I think, in this case. But I did as best I could, objecting to the point where, I think it was disruptive, and I didn't want to be disruptive to the jury. But the judge knew full well my feelings on that count, and I strenuously argued it to the judge pre-trial because I didn't want to have to voir dire on Tom Palanggio being a state representative, which had nothing to do with the central issue of this case, was that Salvatore was alleging that he gave Mr. Palanggio payments over the course of 9 years for a piece of property. So getting to those two issues, which I put in the 12A statement, I mean, here's a successful businessman. He made allegations that Mr. Palanggio accepted money in return for him giving him a piece of property, which he knew Mr. Palanggio didn't own. Mr. Palanggio was a partner with a man named Mr. D'Amico. Mr. D'Amico testified, I never even met Mike Salvatore, and I never had any conversations to sell that property. So my point to the court is, on promissory estoppel, there was never a legitimate promise. There was never a definite promise. And for Mr. Salvatore to rely on something where he knew that Mr. Palanggio had no way of performing on that, it goes against all the case law.
Were there checks running from the plaintiff to your client?
Yes.
Evidence?
Yes, and let me explain that, Your Honor. We never denied that checks went from Mr. Salvatore to Mr. Palanggio. Mr. Palanggio was a very successful used car dealer, and Mr. Salvatore was a tow truck operator. He towed cars, and as you know, when they pick up cars, they put them in the lot, and then he merged into being a used car salesman. So over the course of time, Mr. Palanggio would be his agent at auctions, buy cars for him, get payment for him. They were business people in an arm's length relationship. And for someone to say, hey, look, I paid his Blue Cross, and that was to go towards property that he didn't own by himself, it's utterly ridiculous. It doesn't even meet any of the standards for promissory estoppel. And as far as unjust enrichment goes, Mr. Palanggio performed work for him. He was an agent at auctions for him. Mr. Palanggio had a knack for picking out cars at auction that were worth more than he paid for them, and Mr. Salvatore appreciated that. And so we never denied that money changed hands between them, but we certainly denied the fact that that money was for property that Mr. Palanggio owned with another person. I mean, and if you look at the checks, they were to Tom Palanggio auto sales. They weren't personal checks. So what I think happened here is Mr. Salvatore created a situation where, hey, I'm going to say that he was unjustly enriched. So he did that for 5, 6, 7 years before he figured out he wasn't going to sell him the property.
Mr.
That makes no sense.
DeSimone, you only have like less than a minute left here, but what happened on this remand business? I know it got remanded. Judge Stern exceeded his jurisdiction on remand. Some kind of a settlement or a consent thing entered. Where are we on that?
Well, right now, Your Honor, Mr. Palanggio had a piece of property. I think it was around $80,000, somewhere in that vicinity, and everything has been stopped at this point. I'm sorry, Judge. Mr. Palanggio had a piece of property that he sold, and the proceeds of that property was about $80,000, went to the plaintiff. Since then, everything has been stayed pending the outcome of this court case. As you know, we tried to get a stay so that Tommy wouldn't be threatened with constables and so forth, but the courts denied them all, and he couldn't get a bond.
No, we granted them upon the payment of a bond.
Yes,
which is what the law requires, Mr.
That's right,
We didn't
Judge.
deny it. We
No, I know,
granted
but-
the stay. Your client couldn't pony up with a bond.
Right, and the bond, Judge, is very, very expensive. I think the bond
I
is...
understand that, but nonetheless, we didn't deny the stay.
No, you didn't, but in essence, he couldn't afford to pay for the
I understand.
bond. And so what we did was we compromised and look, here's a piece of property, we'll sell it, you get the proceeds, and let's wait and see what the Supreme Court says about this case, which we thought was ridiculous from the outset. And so that's what happened. So we're looking for the Supreme Court for justice.
Well, thank you,
And-
Mr. DeSimone. Thank you. Your time is up. Ms. Martucci, you have 10 minutes?
Thank you. May it please the court, Attorney Martucci on behalf of Kelly. A couple of points that I want to make to address what my brother had mentioned. The first issue my brother mentioned was with respect to the motion to strike not only count 7, but he also moved to strike 5 and 6 as well. The standard for that is an abuse of discretion, and my brother hasn't really pointed to any factor or piece of evidence that would give rise to a finding of abuse of discretion in this.
What evidence did you present that he violated the code of ethics?
Your Honor,
Okay.
Mr. Salvatore testified that there were threats from Mr. Palanggio that if he pursued active litigation against him, that he would remove him from the tow list, and that he threatened by using his political connections to effectuate that. So in this instance, the amended complaint was filed.
How is that cognizable in Superior Court?
Your Honor, it was that was the only evidence that was presented with respect to that claim.
How is that claim cognizable under settled law with respect to the code of ethics?
Your Honor, Title IX allows civil claims to be brought for different violations without requiring an actual ethical complaint or criminal complaint to be filed. So to
Title IX, what is the citation to that statute? Do you have it?
I do.
You can get it to us after. You can continue with your argument then.
The other issue, Your Honor, is that the amended complaint that asserted counts 5, 6, and 7 was filed in 2015. There was no motion to dismiss those counts, including count 7. There was no motion for summary judgment on those counts. And this entire litigation, this was a jury trial. So my brother was fully aware that a jury trial was demanded on this ethical claim, as well as the other 2 claims, and never moved to do anything about it until the day before the trial started. And he attempted to use a motion in limine for a dispositive purpose. And while he called it a motion to strike, he was ultimately asking the court to dismiss these counts before any evidence was presented to the jury.
And there was no motion to sever under the
There was
rules
no
of civil
motion to sever.
procedure. Is that right?
That is correct, Your Honor. There was a motion to strike that was denied. Now, it's also important to note that it wasn't just denied, but the trial court specifically and expressly limited in his ruling the amount of reference that could be made to Mr. Palanggio's title as a state representative. He put specific limitations on that before the trial started that were put on the record. And throughout the course of the trial, there were substantial limitations on any reference to a state representative. So to say that plaintiff presented all of this evidence in an attempt to prejudice the defendant is just untrue, in the sense that there were sustained objections and orders to strike certain references. And the only time that the state representative title was referenced was with respect to the allegations that he abused his political connections as threats against Mr. Salvatore, which is the evidence that was presented. Now, ultimately, the court found that there was not enough evidence and dismissed that, but to allow that to go to a jury was entirely proper. And there was certainly no abuse of discretion, particularly when there were substantial limitations on the references that could be made anyways. And it should also be noted that it was defense's counsel who brought up over and over again on voir dire the fact that Mr. Palanggio was a state representative. So that would address the motions to strike, and that there was no abuse of discretion. As for the promissory estoppel and unjust enrichment claims, the jury weighed the evidence in this case, and they determined
Which was what? What evidence did they weigh of promissory estoppel?
Sure. So on promissory estoppel, there was testimony from Mr. Salvatore that he made several payments and performed several services. There were written checks made payable to the defendant. In those checks, they had, in the memo line, it references the property that was the subject of the litigation. There was a written offer to purchase that was undisputed that the defendant prepared that specifically referenced these purchases. And there was testimony from Mr. Salvatore that he was promised over and over and over again that these payments would be applied to, and these services would be applied to the services, to the purchase of the property. Now, Mr. Palanggio had conflicting evidence, albeit he didn't have any documentary evidence, but Mr. Palanggio presented a position to the jury that these payments were for the purchase of used cars or at auctions or whatever. The jury weighed all of that and determined the credibility of the witnesses and ultimately believed Mr. Salvatore in his testimony that these promises were made by Mr. Palanggio, that the payments would be applied to the purchases of property. So that the jury found that there was a clear and unambiguous promise here to apply these to the purchase of properties, and that promise was made by Mr. Palanggio. And in fact, Mr. Palanggio doesn't dispute that he received all of these payments. So to say that there was no evidence that reasonable minds could differ on is a farce. The trial court also noted that while there was conflicting evidence, there was also damning evidence in favor of the plaintiff because the defendant did not have any documentary evidence to support his contention that these had something to do with used cars. Contrary to that, there was a written offer to purchase that he, the defendant, prepared, and there were multiple payments and checks that were cashed by the defendant with under no limitation or reservation. They said that these would be applied to specific properties, and that never occurred. So that addresses the promissory estoppel claim, and it's really similar for the unjust enrichment. There was no dispute by the defendant that he received the benefit of these payments and these services, and he retained that benefit to the detriment of Mr. Salvatore. All of that evidence was presented to the jury. The jury deliberated, ultimately weighed the credibility in favor of the plaintiff, and rendered a verdict as such. There's simply no basis to set aside that verdict in this instance. And frankly, my brother doesn't point to any evidence that was overlooked or misconstrued by the trial court with respect to denying the motion for a new trial. And there certainly is evidence that reasonable minds could differ on with respect to the denial of the motion for judgment as a matter of law. So if you take the standards for each one of the motions that my brother filed, he just hasn't met any burden that would give rise to setting aside a jury verdict. This was a 5-day jury trial. The jury deliberated, and that was the conclusion that they came to. It was supported by the evidence.
So tell us about your view on this purported consent decree that entered.
So
what happened?
So as it stands right now, there is no written settlement that was vacated. But what happened was after the verdict came, the parties entered into a consent order, and then Mr. DeSimone took his appeal. We filed a motion to dismiss based on the fact that there was this consent order.
Say that again. After we remanded this case.
Yeah. Yes, Your Honor.
So it was after the remand that this occurred. Is that correct?
It happened twice, Your Honor. It happened immediately after the trial, and then that was thrown aside. And then on remand,
thrown aside. We don't have. What does that mean? Who threw it?
So when this went up to appeal, we filed a motion to dismiss, and then there were some issues with the consent order itself, where the parties entered into a new version of the consent order, and that's what was vacated on remand upon finding that the trial justice didn't have any jurisdiction to enter that consent order. So it was just
Because the appeal had been docketed.
All right, what did you consent to?
Payments on the verdict. So certain payments would be made on a pay schedule as well as
judgment. Yeah, on the judgment.
On the judgment, yes, Your Honor.
So your client received $80,000 after it was vacated. Did he give it back, or does he still have it?
That was from the sale of a property. We didn't receive any payments from the defendant. It was, the $80,000 was for the sale of the property,
Who did the 80,000 go from to?
from the defendant to the plaintiff.
Okay, first, and you're saying it's entirely different transaction on another sale of property that's not involved in this case?
Was it a cash transfer or a deed transfer?
It was a cash transfer, Your Honor,
Okay.
to be applied toward the judgment per the
That's
consent order.
Justice Clarity's question.
That's my question. So after you vacated the consent order, what happened to the money? Did you get it back?
No,
Well, why, if there's a judgment on appeal, a consent judgment that was vacated, why wouldn't Palanggio get his $80,000 back in the meantime?
because the verdict itself hasn't been satisfied, and there was no.
You mean,
But it's on appeal.
Correct, it's on appeal, but there's no stay on the execution.
There's no stay, okay.
Judgment. So because there's no stay, the plaintiff executed a judgment, executed execution.
Okay, all right.
Thank you very much. Mr. DeSimone, you have a 2-minute rebuttal.
Thank you, Your Honor. Just initially, that's why we have judges, so that the jury wouldn't be confused with promissory estoppel and unjust enrichment. It should have never went to the jury. The judge should have dismissed it at the end of when they rested. There was no definite promise. I mean, you look at these checks, Your Honors, and I understand there's a lot of paperwork here, but $4,300 in 2005, $1,408 in 2006. I mean, this is ridiculous. You got Blue Cross payments from 2008 to 2011 totaling $14,000. They filed suit in 2015. I mean, obviously, something happened between Mr. Palanggio and Mr. Salvatore. But I think we all know that a person like Mr. Salvatore, who has 15 to 17 houses, he has 4 or 5 realty businesses. You think he realistically gave money in these increments towards a piece of property?
What's on the memo on the check, Mr. DeSimone?
There were some checks that had Pawtucket, whatever, like different references to things of that nature. But
Things
Palanggio's position was
things of what nature, like real estate?
No, there was a couple of checks, Your Honor. In the memo, it referenced PAW, something like that, PAWT, things of that nature.
That's where the real estate was in Pawtucket?
Yeah, well, his story has changed. Then he said he had options for other pieces of real estate. So this gentleman, on a P&S that he submitted, he said 100,000. He told the payments total 174,000. Do we really think he was that naive? I think there's a personal thing here, and that's why he created this ridiculous complaint alleging an ethics violation so he could smudge Mr. Palanggio's reputation. And not only that, he got the court to allow him to proceed with promissory estoppel and unjust enrichment. I mean, this is an arm's length transaction. Mr. Palanggio selling cars back and forth. This occurred over 9 years.
Thank you very much, Mr. DeSimone. Appreciate it. Thank you. Thank you very much. Ms. Martucci, you as well.
Thank you, Your Honors.
Okay. hearing. I will call the case, ask counsel to identify themselves and to advise the time they'd like to reserve for argument. Good morning. The Rhode Island Supreme Court full argument calendar for Tuesday, October 6th, 2020 at 10:30 a.m., State of Rhode Island versus Andrew Smith. Counsel, please identify yourselves and advise the time that you would like to reserve for argument.
You're muted, Karen. Ms. McGuire, you're
No,
muted.
she's all set.
No, she's not.
We can't hear you. It's not muted, though.
No.
No.
Please enable your audio. On the top left, you will see options: File, Edit, Share, View, Audio, and Video. That drop-down allows you to select speaker and microphone settings.
I don't have that. Ms. McGuire, can you hear us? Nod if you can. You can hear us.
You can't hear me, okay.
There you go.
Oh, we hear you now.
You can now, sorry about that. Kara McGuire, on behalf of the appellant, Mr. Andrew Smith, I would like to reserve 30 minutes for argument and 10 minutes for rebuttal.
You may. Mr. Murphy?
Owen Murphy for the state. May I please have 20 minutes? And is this better?
Yes.
That is. That is
All right, great.
much better.
I think I'm good.
Ms.
Thanks.
McGuire, you may proceed.
Don't let him go far, Mr. Murphy.
I got my computer to work finally, so.
Okay, all right.
But
Mr. Smith was convicted of possessing child pornography without a jury ever having decided that he actually possessed child pornography. The judge instructed that the parties had stipulated that the images were pornography.
Well, did they?
No, they absolutely did not.
How do we know that?
It's not in the transcript. It wasn't discussed at any point in the record.
Okay. Well, you may very well be correct, Ms. McGuire, but I charged a few juries over the years. And if counsel had come to the sidebar and said to me, Judge, there's no stipulation, I would have immediately corrected that 10 ways to Sunday.
Yes, I'm sure you would have. And
that didn't happen here.
No, it didn't. And the problem here was that Mr. Smith realized the error too late. So he realized.
How do you know that?
He pointed out the instruction in a memo filed on December 7th. In a memo filed on December 7th, which is Appendix C.
Is that after the verdict?
It is after the verdict.
All right, so we got some great almighty advisor, and they advised him on that. But let me say this. This issue is not preserved. What do we do with that?
You're correct. It's not preserved. And I think the question here is, when you have an error this egregious, when the jury wasn't instructed on this, an essential element of the crime, what do you do? And I think...
Well, if we had you're arguing plain error.
I am.
Have plain error.
I am.
We don't have it.
I know.
Okay. So what do we do? We don't have plain error.
Right. So I think we have a few options. I think the first option is you are the appellate court. You decide the appellate scope of review.
Don't we have a rule that you have collateral review on an issue that's not appealed, that is not preserved?
Mr. Smith could not bring any sort of collateral PCR because he can't allege ineffective assistance of counsel. He was his own counsel. So this is.
But you're not arguing that. You're arguing the Constitution, are you not?
Right, but
that attacks the validity of the conviction, does it not?
It does. I think there'd be some res judicata issues.
So if you can't argue it on collateral review, then you really have nothing to say to us on the error, then do you?
I do, which is that you decide the scope of appellate review. So I think in this unusual circumstance where
we don't decide. We have settled jurisprudence. We don't pick a case out of nowhere and say, well, we're gonna find an exception here. I don't decide that.
I think in augmented review here, it doesn't.
Would you say that again? I missed you.
If you review this case and if you review this error, it wouldn't have any impact on the Superior Court. It's not like overturning some sort of precedent.
What is the basis for us to do it?
I think it is an unusual circumstance, and it was.
Why is an unpreserved jury instruction an unusual circumstance?
Because the jury was incorrectly told that these images were child pornography. I mean, it's like it was a sham trial. The jury never actually decided one of the most contested issues in this trial. Mr. Smith served almost 3 years in jail, and a jury never decided that these images were child pornography. It's very important. It is very unusual. It's a pro se litigant. I think there's also, in Flory, this court did mention in Flory.
What did we say? I'm sure it's dicta, and you dug it up, and it wasn't from me. I'll tell you that without even looking at it.
That's correct. It was
all of that is correct.
It was Chief Justice Patel, and it talked about when we would review unpreserved jury instructions, unpreserved error in jury instructions, and that was a basic constitutional rights issue, which we clearly have, that the record reflects the failure to object was not a deliberate trial tactic, which it clearly wasn't with Mr. Smith, and that the error complained of was more than harmless error, which it certainly is.
And that what? The error was what?
More than harmless error, which it was. And then I think that this court and should.
Don't we have something like it's a new rule of constitutional law?
Yes, and I tell
you didn't tell us that. Tell us the rest of it.
Well, Florida doesn't say that, does it, Mr. McGuire?
No, it doesn't.
It does say, though, constitutional violation, doesn't it?
Yes.
It doesn't. It just doesn't say no.
That's correct.
And then I wrote one after that, did I not? And in that one, I made it abundantly clear. There is an exception for unpreserved errors. And it has to be, and Justice Robinson has written several of them, it has to be an error of constitutional dimension. And it basically has to rise to the level of new law. Probably Ornelas would be the best example that we have in terms of the standard of review on constitutional claims. I mean, that tipped the table over on the standard of review. There are several of them. I was in law school when In Re Juvenile came down, on the burden of proof. I argued that before the Supreme Court, In Re John Doe. So there are a lot of matters that are of new constitutional law. And those issues apply to anyone, to the person raising it on appeal, and any case that's in the pipeline, as I understand it.
Yes.
On that last part, but I'd have to look it up again. But we don't have any of that here.
I'm suggesting that you make an exception, or
Can you get a little closer to the microphone, because it's not coming in that well.
Is this a little better?
Yes.
Okay. And I think the other thing, in addition to this court making an exception in this case, is to note that we are in the real minority on plain error. So in my reply, I studied over 40 jurisdictions, some version of plain error. And in fact, those 40 cases that I cited are cases where state courts have vacated convictions because of erroneous jury instructions where defense.
So you're asking us to adopt plain error?
I think that's one avenue that you could take, Your Honor. I discussed in my reply two very similar cases to this one, Bartlett and Vigil, and in both of those cases, the trial judge failed to instruct on an essential element, and those convictions were vacated on appeal.
What jurisdictions were they?
Bartlett is Nebraska and Vigil is Wyoming. But in my reply, there's a whole host of over 40 states that have applied a plain error to jury instructions.
Have what? You know,
Applied plain error to jury instructions. And I think jury instructions are particularly apt for plain error, or you know, particularly ripe for plain error to apply, because a judge does have an obligation to correctly instruct on the law.
we don't have an evidentiary record here. And how do we know the counsel and your client didn't reach some kind of an informal agreement that, hey, this is child pornography, and he did define it, but it's not computer enhanced child pornography. You're asking us to take a huge leap on a paltry record.
I'm not, Your Honor. The state
But you kind of are.
No, I'm not. The state does not cite a stipulation in the closing. The state does not, and I think they would if they had a fact.
In the closing, what do you mean a stipulation in the closing?
So the state doesn't say to the jurors, the parties have stipulated that the images of child pornography were child pornography. Wouldn't he say that in the closing rather than?
We don't know that. Well, I would like to hear why he didn't.
So
there's no record here.
There's no
factual error. This is not an error of law. This is a factual error.
No, it is an error of law because once you
it results in an error of law.
Okay.
But it is a misstatement of fact that may very well have happened and may not.
I think that's a distinction without a difference, that it's a misstatement of fact that results in an error of law. I mean, the jury was told, don't consider this element. I mean, to go on with how there was no stipulation, there's a pretrial order that there's going to be no off-the-record communications. The judge says, page 55, it's a question for the jury whether or not these are depictions of real people. The prosecutor says that, page 46. The judge solicited instructions about virtual child pornography, page 211. In the motion for new trial decision, the judge never mentions a stipulation. I would think the judge would mention a stipulation there if one existed.
And I have a hearing on the motion for a new trial.
Yes, they did.
And that's where he brought it up, right? That's where he brought it up.
I didn't hear you.
I said, that's where he brought it up. That's where Mr. Smith brought up the fact that he hadn't agreed that there was child pornography.
Justice Flaherty, he brought it up in a later hearing on December 12th. The motion for new trial was December 20th, but it was a post-trial.
So the motion for a new trial was heard and denied. Is that right? Okay.
And the judge never mentioned the stipulation. Yes.
What kind of a motion was that?
It was a post-verdict motion. I'm not saying it was a
post-verdict motion.
I'm not saying it was any sort of legally cognizable motion, but it illustrates the point that there was no stipulation.
And had he consulted with an attorney in the interregnum?
Not that I'm aware of.
Well, if we had a hearing, we might know that, right?
I don't think it matters whether he consulted with an attorney.
I'd kind of like to know what the hell kind of a motion this was, with all due respect, Ms. McGuire. Since they had a motion for a new trial, it was heard and denied. The next thing on the agenda after that is pre-sentence report and sentencing.
Your Honor, with all due respect, some of the procedural things may be wonky here, but the point is wonky, but the point is there was no stipulation. And there are reasons here to adopt a plain error exception. I think.
Okay, go ahead, I heard you.
It maintains the integrity of the judicial system, so allowing this court to fix clear errors of law. It honors fairness to the parties, specifically Mr. Smith in this instance, and it serves the purpose of efficiency for cutting out any sort of collateral litigation. I think the bottom line here is that Mr. Smith is now a convicted sex offender, even though no jury found that these images were child pornography. If there are no more questions on the first issue, I would like to move on to the second issue, what is actually the first issue of my brief, which is the opening statement. The trial justice here would summarily forbid Mr. Smith from making an opening statement, and there are two grounds on which he erred. First, he got the law wrong when he denied Mr. Smith the opportunity to open based on the fact that he was not testifying or presenting witnesses. Martinez made this perfectly clear that presenting an opening statement does not solely depend on those two elements.
You know, Martinez, everybody's making a big deal of Martinez. But the rule with respect to opening statements goes back decades. The error in Martinez was that Justice Krauss summarily denied even hearing from counsel with respect to the evidence that counsel expected to introduce. There was a long colloquy with your client the day before the opening of evidence. And your client indicated to the trial judge, I am not going to present any evidence, and I haven't decided if I'm going to open. And Judge Carnes patiently and professionally set forth to him exactly what was going to happen. If you're not going to put on any evidence, then the state I'm going to have the state open and call a witness. And that's what happened until the state finished and your client got up and said, I want to address the jury. At that point, the trial judge said, sit down.
Mrs. Goldberg,
and your client cited Rule 26.2 to him.
I read that day before the trial transcript a little differently on page 153 and 154. And I just reread this morning. And
so did I.
What I saw there was Judge Carnes actually never tells Mr. Smith that what he is doing is his own sua sponte.
What? He doesn't.
What he is doing is his own sua sponte analysis of whether he's going to present opening. So he doesn't say to Mr. Smith, okay, Mr. Smith, now we're going to decide whether you're opening. He just says, are you presenting witnesses or are you testifying? And then he says, okay, the state can open. He doesn't say you can't open or you can't
say, okay, the state is going to open. That isn't what he said.
He does say that. He doesn't say that Mr. Smith can't open. So I think it's not clear then to Mr. Smith that that is what's going on. And then the next day.
Well, then if it's not clear to Mr. Smith, you in your reply brief, you wrote the reply brief, you said the trial judge acted unlawfully. You didn't mean that, did you?
He did act unlawfully because he
violated the law?
He acted, he decided it unlawfully.
Is this an abuse of discretion standard?
No, it's it's de novo error of law. And I'm arguing that it was not a lawful reason to deny it. And then once the state does open and Mr. Smith jumps up on page 170 and says he would like to open, and by the way, that is the same point at which the lawyer in Martinez jumped up, so there's nothing wrong with waiting until that moment to ask to open. He jumps up and he asks to open, and he is told to sit down. At that point, the judge says, sit down right now. We are on the record yesterday afternoon. Based on what you told me, I'll let you wait until the time to make your case.
Ms. McGuire, that's where I see the problem here is because when it says sit down, this was on the record yesterday, but there's not really much on the record yesterday.
That's correct. So I think that's where the problem is, Justice Flaherty, because what's on the record yesterday is just sort of that question and answer between Justice Carnes and Mr. Smith about what he's going to present. At that point, I think the appropriate thing was,
Mostly about what he was gonna, whether he was gonna present any witnesses or whether he was going to testify. He really didn't ask him what he might want to bring out on an opening statement. And then.
He's not required to do that.
But you agree with me that, that when the last colloquy, the last of the three conversations they had about that, when Mr. Smith said, so if I'm not going to testify, I can't open, and Judge Conn said, yes, that's right. But that was too late for him to open, wasn't it? His witness had already started testifying.
I think that third discussion, that is already after the state's witness had.
Can you need to say that again? You don't have real clear audible here.
Justice Flaherty, you're correct on that, which is that third discussion happens after the state's first witness.
So which would have been too late for Mr. Smith to open?
I think arguably he could have, because actually cross-examination hadn't begun at that point. It would have been a little odd, but no cross-examination had started. So
all right.
Well, that's not what Rule 26 says.
No, it's
Rule 26 says before the presentation of evidence. You know?
So your case
Just to make it up again.
It was, Justice Goldberg, it was at least brought up 2 times before the presentation of evidence.
I am not disputing that.
Your case really hangs on that first and second conversation for the most part, doesn't it?
I think it does. I mean, I think the third and fourth conversation, well, not less so the fourth, but I think the third conversation.
What about the third one, though? Let me ask you this. On page 154, the day before they open, that's what I want to clear up a couple of things. You don't have any witnesses you're going to call, right? No, just the witnesses he's called. Okay, what I'm going to do, I'm going to let the state open. But if you don't have any evidence, the state, and then it goes on, they go off on, I guess he's more worried about his divorce that day, but your voice is now I'm going to let the state open and call witnesses. And then there's no discussion.
I agree with you. I mean,
there's nothing about him opening.
Well,
I agree. So I think he does, when he brings up opening, it's after the state's opening, and he's completely shut down. So under Martinez, they
discussed it the day before. So that's, you know.
With all due respect, you just read it, and I think one interesting thing is he says, no, just the state already brought. I mean, that to me is that he wants to cross-examine these witnesses. He would have called them unless it just, so, I mean, I think this.
But it's incumbent upon him to indicate that to the trial judge. And it's incumbent upon the trial judge to listen to it. And that's all we said in Martinez. And to the extent Martinez, you know, you're trying to read Martinez into something else, Judge Krause abused his discretion at the sidebar. And your client cited Rule 26.2 to the trial judge. So he knew the rule.
With all due respect, I think this is actually worse than Martinez because he doesn't even get a chance to explain. And I think he doesn't get any chance to explain on page 170. And I do think this is another example, stipulation, that I think this is another example, like the stipulation, if Smith was not treated the same as another litigant, even though he's pro se, and he's held to the same standard.
Well, you're not suggesting that he gets special treatment.
No, not at all. I'm suggesting he should get equal treatment. I don't think he received in this case. I have a few minutes left, so I'll move on to the third issue, which is that the trial justice erred by denying Mr. Smith's motion to suppress. The search warrant and arrest warrant in this case were signed by a traffic tribunal magistrate. And
whose burden was it, Ms. McGuire, to show whether or not Magistrate Goulart had the requisite authority to sign the warrant?
It's my understanding that it was the state's burden to show it once Mr. Smith raises the issue of statutory authority. So I think if you look
How
at,
did he raise it? I mean, does he have to raise it with more specificity than saying that no traffic tribunal magistrate has the authority to sign it?
I don't think he has to be more specific than that. I mean, I think he was.
You think it has to be more specific than that?
No. I don't think it has to be more specific than what he did, which was.
He wasn't specific at all, because you know that on some occasions, magistrates do have the authority to sign warrants, don't they?
Yes, that's.
So he was just raising it as a blanket. No magistrate has the authority to sign a warrant. He didn't get into, yes, I understand that traffic tribunal magistrates who have been designated to sit as district court judges can sign warrants on occasion, but Magistrate Goulat did not have the authority. He didn't say that. He just did it as just a general thought. They don't have it. None of them have any authority. Isn't that what he said?
That's correct.
It's flatly wrong, isn't it?
I mean, as broad of a statement as that is wrong, but I think.
Okay, so based upon that, who had the authority then, who had the responsibility to show that even though it's not argued, Magistrate Goulat did have the authority in this case?
I think once Mr. Smith puts the state on notice that he's arguing with the statutory authority, I think it's the state's burden to come forward and show, well, look, 8-15-.
I agree with you. If they had put the state on notice that despite what the statute says, nobody authorized Magistrate Goulat to sign this warrant.
Mm-hmm.
And then they might have had that, but he didn't do that. He said, whether it's Goulat or Newman or the chief, DeSandro, none of them have the authority. That was his argument.
Mm-hmm. And
What about the fact that he waived? He waived a hearing. He was looking to dismiss this case.
Just to answer your question, Justice Goldberg, the hearing that he waived was about another motion to suppress. It wasn't this one. So that's.
It was with respect to the warrant, because the trial judge.
It was with respect to the Arizona search. So that's page 75. Now, the only issue for suppression is what is in the email chain and what those attachments were. Anything that was seized from your computer is not going to be.
What about the motion to dismiss?
What about the motion to dismiss?
Well, that's what he was seeking.
And then he also sought a motion to suppress. But the motion to suppress where he waived the hearing was a completely separate motion. I'm sorry, just for clarity, I was also responding to your question, which is whether they're on notice. And I think that they were, because you also have the state coming back and saying, oh yeah, he does have authority, so they know what's going on, but they point to 1210-2, which is the Justice of the Peace statute. So they're like totally off base. And then what Justice Karn says is, oh, they can appoint him, and then, leave it at that. Nobody, and actually to this day,
That's my point, Ms. McGuire. I can understand that Justice Carnes would say that, because that's the objection that Mr. Smith raised. None of them can appoint. So the judge says, yes, they can appoint. I mean, he did not articulate, yeah, some of them can, or they can at times, but in this case, Magistrate Goulat did not have that authority, and that would have required a different inquiry. Do you agree with that?
I don't, because I just don't think it was that much of a leap for the state and the judge to understand what he was saying. And I think, it's interesting that to this day, the state never introduced any evidence of whether this appointment was consented to and whether the magistrate had the authority. And, the basis for the trial judge's denial of this motion was that the state represented that none of this evidence is coming in. Then the state did use it, did introduce evidence of executing the warrant, did testify about the computer being seized. And you know, as to whether Mr. Smith then objected again at the right time, page 297, 298, when Mr. Smith tries to jump up and say, hey, again, by the way, one of 12 times that the magistrate had no authority, Justice Carnes said, I've made rulings on. So it was something that was.
He went into these long diatribes about no magistrate has any authority. They're a civil court and all this. I mean, he really did not focus in on this magistrate. So, I mean, I don't know if it's fair to require either the state or the trial judge to make a leap.
I just think it's not much of a leap. I really don't.
It's not that much of a leap, it's a leap.
And I think it's really,
Compared to the other leaps you're asking us to make today, it's not a big one. I tend to agree with you, but it's nonetheless, Justice Flaherty is right. It's a leap.
I think it's par for the course on the way that this trial proceeded. And certainly Mr. Smith didn't have a lawyer, and some of these things might have been.
You know, you're not suggesting that he was treated badly by Justice Carnes. Justice Carnes bent over backwards in this case to give him, I mean, he even said it. I don't want to be disrespectful. He said it over and over again on this record. He was a modicum of professional judicial temperament.
I have a few seconds, so I'd like to just wrap up. I think Justice Carnes treated Mr. Smith politely.
I can't hear you again.
I think Justice Carnes treated Mr. Smith politely, but Mr. Smith was wronged in this trial. He was wronged when the trial judge denied the motion to suppress without actually deciding whether the tribunal magistrate had authority. He was wrong to instruct.
Thank you, Ms. McGuire. Your time is up. Your time is up.
If I could just get through this
Thank
last.
you. Mr. Murphy?
Okay. Thank you.
Hello again, Your Honors. Okay. I'll follow the course of proceedings this morning. I'll take the second issue first. Your Honors, the state would submit that, and it's well known that this court's waiver rule is particularly taxing in the realm of jury instructions.
Do you concede, sir, do you concede that there is no evidence in the record of a stipulation?
I concede that nothing on the record says one way or the other whether there was a stipulation.
And that's what the rules require, isn't that right?
Yes, I think at least this court's guidance has instructed trial justices and litigants to memorialize stipulations on the record.
And it's in the rules, isn't it?
No.
Is it in the rules? It has to be in writing or on the record?
It's in the case law.
I'd have to double check if it was in the rules.
All right.
Case law, and certainly
And this trial justice specifically, in addition to the case law, said no informal agreements will be tolerated, or words to that effect.
No informal agreements will be tolerated in respect. You'd have to refresh my memory, Your Honor. He said that in respect to.
Everything will be on the record or not.
It's certainly possible that he said that. Yeah, I think that would make sense. I think he mentioned that he wanted to do a lot of the sidebars. He wanted all of them on.
Record.
I think that's what he said.
He graciously allowed a pro se defendant to approach the sidebar, all of which was to protect this defendant. Is that right?
Yes, Your Honor. I think his statement to that effect was to protect the record and probably to protect himself, given some of the unwieldy allegations and statements that arose from Mr. Smith during the course of the proceedings.
Well, there's no question he had a hot potato on his hand here, and this is a white knuckle ride in many respects. But there was no objection at the sidebar by either side.
That's correct, Your Honor.
Okay.
And I would say that both myself and the public defender's office, we put a good amount of time trying to track down the stipulation. We didn't find anything. Even speaking to the trial prosecutor, who didn't have a memory one way or the other, he can neither confirm nor deny the existence
Well, Mr. Murphy, the actual instruction that they had stipulated that the matters were pornographic was requested by the trial judge. I'm sorry, by the prosecutor and adopted by the trial judge. Isn't that right?
That,
Including the stipulation?
No, that was his request for instructions. Wasn't it in his request for instructions?
The trial justice requested each side to submit jury instructions, their
Right.
proposed jury instructions.
And yes, and when the prosecutor submitted his request for instructions, in his submission there was a stipulation. And there wasn't any stipulation. Isn't that true?
I think there may have been a stipulation. I don't know. I can't say one way or
You
the
told
other.
me there wasn't a stipulation. I'm confused now, sir.
There's no stipulation on the record. That's certainly clear. Whether or
One
not
way or the other.
Okay. Well, when the prosecutor asked the judge to instruct, the parties have agreed that it's pornographic material. He asked them to instruct that, and he did instruct it. He adopted that request from the prosecutor. Isn't that true?
I believe the prosecutor submitted draft instructions that both Mr. Smith reviewed and the trial justice reviewed, and ultimately that instruction made it into the final instructions.
Okay, you're starting to sound like one of President Trump's press people. It's a simple question. Didn't the prosecutor's request include a request that the trial judge instruct that they had agreed that it was child pornography?
I'm not
sure.
sure.
It's okay.
I don't know. I
Well,
believe
if he did, that tells me that there was a stipulation. Because you have an officer of the court submitting a request to a trial judge. And if that doesn't point up the need for a hearing in this case on collateral review, nothing does. Because there is no trial attorney on God's green earth that would submit that in the absence of an agreement, informal or otherwise.
Unless they made a mistake.
Well, don't we need a hearing on that then?
I don't think so.
Oh, well, let's just say plain error then. Let's take a leap and call this plain error.
Go ahead, Mr. Murphy.
Thank you. What I can tell you, Your Honor, is that throughout the record and throughout the course of these proceedings, the defendant effectively admitted that the images in his possession were child pornography as the justice defined it and as the statute defines it.
Didn't he talk about photoshopping and that kind of thing? Something to derogate from it really being an actual photograph?
So 4 of the images, yes. 4 of the images he claimed that they had been doctored in that certain aspects of the images were superimposed onto a child in a compromised position, including shoes that he suggested weren't naturally part of a photograph. And he said of another picture, this penis was too large next to her head, that it had to have been 2 pictures combined.
Oh, God.
But those, even if he's correct about that, and I had the misfortune of looking at some of these images myself, I don't see it. It's in the court's file. Certainly, Your Honors could take a look if so inclined. I don't see how they're doctored, but even if he's correct about that, the images still meet the definition of child pornography as defined by the legislature and as instructed by the justice to the jury. And so that's 4 of the...
That may, but he was adamant that he was not, that they did not. He wasn't agreeing that they were. He was adamant throughout the whole trial that they, not only were they photoshopped, but they were just naked children that does not meet the definition, right? All
Right.
the trials said they were.
Defense in this case was it might be child pornography, but it's computer altered, so therefore I'm not guilty.
He did suggest that it was computer altered as a basis to suggest that this was the conspiring of the government and the FBI, and that obviously they're the ones who created these false images.
Okay.
And so he marshaled it for that purpose. But he also, I'd say his suggestions that it wasn't child pornography was a mistake of law, but it doesn't negate the fact that he was admitting that these images factually met the definition of child pornography. And as far as the 5th image, a similar.
Your last sentence just doesn't parse. Either he was admitting it was child pornography, or he was saying it was computer altered, and therefore, according to him, was not child pornography. You can't have it both ways.
I think he made a mistake of law. He said that, hey, look, this has a minor in a compromised position and as far as the fifth image, making a lewd exposition of her genitals. But Rhode Island law permits those types of things, which it doesn't. So, I mean, he admitted to the facts where he was mistaken on the law, and he adopted the facts that the trial justice ultimately instructed on, is what I would say.
Well, but he didn't. The trial judge didn't instruct on the facts. He just said there was an agreement.
Correct, but he did, he said there was a stipulation. He did, however, continue to instruct on the elements of child pornography.
Did it matter if the jury had that issue taken away from it by virtue of this non-existent stipulation? The jury didn't have to wrestle with any of this photoshopping or anything else. It was concluded for them.
No, that's not what he said in the instructions.
He said it was stipulated to be child pornography.
But the defense was yada, yada, yada.
Mr. Murphy, you want to answer that question?
Yeah, I think this case law, this court's case law on harmless error as far as issues of due process is concerned is that the court will deem an error harmless where the fact is necessarily on the record or admitted to by the defendant. And the state's suggestion is that in adopting all the elements of child pornography and presenting these issues to the jury, the defendant made an admission of how the constitution of these images such that any error was harmless.
This is what the trial judge said. In this case, the parties have agreed by stipulation that the images entered into evidence are visual depictions which depict minors who are engaged in sexually explicit conduct. That's the entire stipulation.
Right.
It says nothing about child pornography. It doesn't, the term, and then he goes on to define sexually explicit conduct. Then he says, now there is a affirmative defense that is available. The defense is found in the section of the statute relative to the possession of child pornography, which is the charge here. It shall be an affirmative defense of violating that the defendant possessed less than 3 images in good faith, yada, yada. If you find that he possessed less than 3 or more than 3.
Yeah, I mean, I thought that was an interesting aspect worth noting, the harmless error argument. And I think exactly what Mr. Smith said about the images is what the justice instructed. But I think probably the easiest way to conclude that this issue was waived was the fact that, I mean, there's certainly no novel rule of law applied here. This was a factual statement that took place about a particular case during that case. And so I'm running a little bit low on time here, but the state would certainly submit that issue 2 should be resolved in the state's favor. Now, as far as the opening argument statement, I mean, the primary flaw with the defendant's whole argument is that the onus rests on him to direct the trial justice to the fact that he's going to be presenting some type of evidence that warrants an opening statement. And in this case, the defendant had an opportunity to do that prior to the trial, and he basically said nothing to the trial justice. He left it to the trial justice to poll him on what exactly he intended to present. It was one opportunity he had to raise the issue of affirmative evidence. And so when the next day came, I'd agree that the trial justice was a little bit short in telling the defendant to sit down. I would suggest that that was probably a reasonable exercise of his duty to maintain courtroom decorum, given what had happened with the defendant up to that point, and also based on the prior day discussions. But the defendant
said to him, based on what we talked about yesterday and what you told me yesterday. That's what he said.
Correct. And I'm suggesting that while the justice was short in that moment by telling him to sit down, I think there was ample reason for the justice to be short at that time based on Mr. Smith's behavior. But regardless, he gave him, Mr. Smith, an opportunity later that day to preserve the issue on the record, and Mr. Smith said nothing about his want to provide his own affirmative evidence.
Well, Mr. Murphy, would you agree with me that when, in the second conversation, when the trial judge said, sit down right now, we were on the record yesterday afternoon, based on what you told me, I'll let you wait till it's your time to make a case. The day before, which is the conversation he's referring to, they really didn't talk about opening statements by the defendant.
You're right, Your Honor. It seems as if maybe that's what the trial just was getting at based on the questions he asked. But
he doesn't. He never said, you know, you're going to put on any evidence. You got any evidence? He talked about the opening statement of the prosecutor, and then he said, after the state rests, you can make the decision whether you'd like to testify. We're going to have you come to the stand. We're going to have you take an oath and give a narrative. He never discussed an opening statement by the defendant. And then when you look at the second day's transcript, it looks like he thought he did, because he said,
Well,
hey,
he
based on
did,
what we
because
talked.
he said,
Let me finish. Please, let me finish.
What I'll do is, after
Goldberg.
the state opens, then I'll
Let me finish.
I'll
Let me
let
finish
the
my.
people go there. You missed that part.
No, I didn't miss anything. Just let me finish my question. So when he said we were on the record yesterday, there really wasn't much of a discussion on the record about an opening statement by the defendant, was there?
I think that, well, first of all, put in context, I think the judge was describing the context of the proceedings. Opening statements were certainly on the table, and the justice was asking questions that were germane to whether or not the defendant had a right to make an opening statement. Now,
Which question was that?
Asking about the defendant's case and what evidence he intended to put on, whether or not he wanted to testify.
Well, as I read the transcript, the court said, are you going to testify in this case? Defendant, I don't think so. And the judge says, that's what I want to clear up. A couple of things. You don't have any witnesses you're going to call, right? Answer, no, just the witnesses he's already brought, which is an inartful way of saying, I'm going to cross-examine the witnesses from the prosecution. But there's no mention of an opening statement in that colloquy.
Well, there is, because the next paragraph is, what I'm going to do is, I'm going to let the state open.
That's right.
But if you don't have any evidence, what I'll do is, after the state opens, then I'll let the state call their witnesses. After the state opens.
That's correct, Your Honor. Yeah, I think that's the justice in that sentence is pretty clearly implying that he's not going to allow the defendant to open at that point. And that's, I'll return to my first point, but the onus rests on the defendant at that point to say that, no, I want to open because I'm going to be presenting affirmative evidence. He doesn't say anything like that. He said he's going to cross-examine witnesses, but that's not a statement that he's going to be presenting affirmative.
Right, but what we said in Martinez, with very experienced counsel and some colloquy between the two, the court said, since the defendant described potentially affirmative evidence in a less than precise fashion, further probing by the trial judge was warranted to ensure the defendant would not summarily and perhaps erroneously be denied the opportunity to present an opening statement. Now, that didn't happen here, did it? There wasn't any further probing. There was no probing at all.
Right, but we hadn't gotten to the point where probing was necessary on behalf of the trial justice, because unlike Martinez, it wasn't as if the defendant said, no, I want to make my opening statement.
Well, but he said it the next day before the state made its opening. I understand your answer. Thank you.
Fair enough, Your Honor. And even taking the sentiment that you're proposing, I think it's important to note that the defendant ultimately did have a chance to preserve the record and made no mention of the fact that, hey, I wanted to introduce this affirmative evidence and discuss it in my opening statement. He just blandly asserted that he had a right to open. And he cited the rule of procedure with really no distinct explanation of what the trial justice had done wrong.
Okay.
It's fair to say that we have a legion of cases. Martinez is the only one that we've ever reversed a trial judge for. And that's because Judge Krause gave him such short shrift. We did not change the law. We have emphasized over and over, we have made it clear that defense counsel must first bring the evidence. Defense counsel must bring the evidence to the attention of the trial justice. That's what we've said.
That's correct, Your Honor.
And Judge Carnes is well aware that he's talking to a volatile, that's a different issue, but a lame person, and he's trying to explain all of this to him.
I can see that I'm running low on time. As far as the third issue is concerned, the state would suggest that certainly this was a harmless error given the record that existed. These pictures were found in Arizona. At that point, the FBI found the defendant's email address and IP address. They followed that IP address all the way to Rhode Island, meet the defendant during the walk and talk, and he confirms that he's looking at these Craigslist ads, that he looks at ads with taboo and perv, and he even goes so far as to say, go ahead, look at my computer. You're not going to find any child pornography, just naked girls, but no penetration, something to that effect. So he then revokes the consent that he was offering. I don't see how anything that stems from the fact that he threw out his computer, which was the at-issue evidence in this motion to suppress that never happened, affects the calculus of the defendant's guilt. And he makes several admissions, too, to his wife, including a letter that he drafts in his hand admitting to the fact that he's interested in child pornography, that he regrets doing it, but hey, this isn't really him. It was just an experiment. And I think that that's the sentiment of that letter. Does the court have any questions about the third issue?
Apparently not.
Thank you, Your Honors.
I'd like to know, Mr. Murphy, does the record reflect that that's Justice Magistrate Goulart had the right to sign the warrant? Probably not. It's not in this record, but I just want to know, did he have the right to do it? Was there an order allowing him to sign that warrant?
So I found, and I think it might have been introduced in the defendant's brief or his supplemental brief. There was certainly an order from Justice Sattel moving the defendant from the traffic tribunal court to the district court, but that in and of itself isn't sufficient because there needs, according to the statute, there needs to be consent from the governing judge of the district court, and that I don't think is anywhere in the record.
Okay.
Thank you. Mr. Aguirre, you have 10 minutes, I believe.
Just briefly, Rule 1.4 of the Superior Court.
Mr. Aguirre, come just a little closer.
Yeah, you got to get another computer for next month.
Okay.
Tell the taxpayers to spring for it.
This is a brand new one, Justice Goldberg, so I'll have to wear headphones next time.
Well, I don't know that it's headphones because we're not hearing you.
Is this
That's
okay?
the problem.
Yeah.
Okay. Rule 1.4 of the Superior Court Rules of Practice provide that any agreement must be put in writing or be on the record orally to have any validity. So I think that was a question.
Have what?
To have any validity. So
to be enforceable.
To be valid. So I think that was a question posed to Mr. Murphy, whether there was there is a rule in a Superior Court.
Did the prosecutor include that in his, as Justice Flaherty referenced, was that included in the request to charge by the state?
It appears that it was included in the request.
It was? Okay.
Yeah.
All right.
And I think as Justice Flaherty said, I think what probably happened is it was a mistake. It was probably taken from another case where there was a child pornography issue.
We don't know any of this. We're just speculating, and you want us to adopt plain error.
And we do
the circumstances. I think it's weird the trial judge wasn't even told about it at the sidebar.
I think it's very troubling that the state, even now, can say maybe there was a stipulation, maybe there wasn't. This is a man's liberty. He went to trial so that a jury could decide this. A jury did not decide it. He went to prison. He is now a convicted sex offender. As Justice Robinson pointed out, this virtual pornography argument, that's something that the jury could buy. And it was the jury's right to consider whether or not it was virtual pornography. It was also...
Is there a verdict sheet in this case?
Yes, there was.
Did you include that in your papers?
I did not, but I think the state has it in their appendix, actually.
Okay, thank you.
It was also, it should have been the jury's call whether the affirmative defense applied. And whether, even if some of the 5 images met the definition, whether he deleted it. All of this fact finding was completely taken away from the jury. The state did not have to prove this element beyond a reasonable doubt. And this was just not a fair trial. Thank you.
Thank you.
Thank you very much, both of you. That concludes our calendar for the day.
Thank you.